Marriage is not a factory for childbearing. Marriage exists to encourage men and women to create the next generation in the right contexts, and simultaneously to discourage the creation of children in other contexts out of wedlock in fatherless homes. Children in single-parent families, children born to unmarried mothers, children in step families or cohabiting relationships face higher risk of poor outcomes than do children in intact families headed by two biological parents. Parental divorce is also linked to a range of poorer academic and behavioral outcomes. Part A of my note is, my lords, where I'll just give a brief. Wherever your lordships want me to stop and elaborate, I will. Yes. I'll just give an outline, my lords. So the first part A really deals with two submissions, my lords. First, I have tried to submit that there's a basic structure of the marriage, and that is a union of man and woman. The second submission I have, my lords, is gender fluidity. I'm not elaborating, my lords, I'm just stating my propositions. And the second submission I have is that gender fluidity is impermissible where cisgender is core. And ignoring rationale of valid classification amounts to perpetrating inequality. Then I've given examples of areas which have been reserved specifically for women. Because if these spaces are diluted in any manner, then what will be lost is really the cause of women's equality, women's well-being, women's empowerment. That is my second point, my lords. And I've given examples like women's recruitments, spaces which are specifically for women, women's washrooms, women's correctional homes, women inmates, welfare homes, ladies' barroom in the Supreme Court. When your lordships recognized in NALSA transgenders as a third gender, your lordships did not, using the expression that Mr. Datar did, my lords, did not retrofit in the two existing genders. Your lordships identified them as a third gender. So, my lords, it's very critical that gender fluidity cannot be permitted in areas where cisgender is core. That brings me, my lords, now to part B. That is specifically with regard to children. And, my lords, the preposition that I have is welfare of child is paramount and sacrosanct and cannot be opened, exposed even for an iota of potential compromise or uncertainty. My lords, for the first preposition, that is the child has a right to be born and raised by biological parents. My lords, for this I will rely on note 2 of the Learned Solicitor General for India, my lords. Your lordships will kindly have page 39 to 49 of that note. There are some research papers also which is there in their compilation, but Learned SG's note quotes the paragraphs that are relevant. If your lordships will kindly take that with me, my lords, page 39 of note 2 of Learned SG. Only for the purpose of these two prepositions, that the legitimate state interest of ideal mode of child rearing. My lords, all children are naturally born only to heterosexual couples. And now, my lords, when I take your lordships through the architecture of, my lords, laws which are relating to children, there are no competing rights in this space, my lords. The only sacrosanct, paramount right is that of the child. To the extent that sometimes a child may need to be protected from himself. The entire, my lords, architecture of these laws are from the concept of welfare of child being paramount. So, my lords, my respectful submission is, if your lordships will, my lords, have page 39 of Learned SG's note, my lords.
Which note?
Note 2, my lords.
Note 2.
Note 2 of the Learned SG. This chapter, my lords, the
violation 2. Note 2.
Note 2. PDF page 39.
My lords, it's running 39. PDF should be PDF of 44. 44
Yes.
It could be, my lords. 42. I'm grateful. 42, my lords.
42.
The legitimate state interest of ideal mode of child rearing. Am I,
Yes.
my lords?
Page 42 starts with note 2, fundamental rights, para 59.
My lords, this is para 63.
63. Very well.
Bottom.
Got it.
Yes.
My lords, will see, my lords, this is for the preposition that legitimate state interest of ideal mode of child rearing. Now, Lordships will, my lords, the fundamental point is that a child can only be naturally born through a heterosexual couple. And therefore, the special significance of recognition of heterosexual marriages cannot be understated from the point of view of child, birth of child and bringing up of the child both. My lords, there are some very interesting papers that have been put together, my lords, in the research of this note. And my lords, these papers show that fathers and mothers both play complementary roles in upbringing of the child. And state is justified in treating homosexual and heterosexual unions differently for that purpose. The first paper, my lords, that is quoted in para 66 is straight is better while law and society may legitimately prefer heterosexuality. Is a paper, my lords, from a professor of law, my lords, of Case Western University, Ohio. Your lordships will find that at page 353. The entire paper is there in compilation, volume 8 of Learned SG, my lords. It's mentioned here. The relevant paras are quoted here. And if I can draw your lordships to the last para that is quoted at the next page, my lords.
Which page?
Marriage, my lords, I am at page 41, the noted page 41.
Yes, but which compilation?
Same thing.
Note.
Same thing.
Was.
Learned SG's note, my lords. I was just giving that the complete paper is there, but the relevant portions are here. So marriage is not a factory for childbearing. Marriage exists to encourage men and women to create the next generation in the right contexts, and simultaneously to discourage the creation of children in other contexts out of wedlock in fatherless homes. Well, that's the next paper that's in para 68 is marriage from a child's perspective. How does family structure affect children and what we can do about it? Please see the highlighted portion. It is not simply the presence of two parents, as some have assumed, but the presence of two biological parents that seem to support child development. Children in single-parent families, children born to unmarried mothers, children in step families or cohabiting relationships face higher risk of poor outcomes than do children in intact families headed by two biological parents. Parental divorce is also linked to a range of poorer academic and behavioral outcomes. The next paper, my lords. This is my lords, a Pennsylvania University law professor. The next paper is Tradition, Pluralism and Same-Sex Marriages. This has 4 authors, my lords. The paper your lordships will find in volume 8 of the Learned SG's compilation. Please see, my lords, the highlighted portions in the second para. To date, the research on child well-being and family form bears out that children thrive on structure, order, routine, stability, continuity, certainty, and clarity. The evidence shows that conventional beats unconventional every time. This means that complexities and ambiguities of non-traditional families come at a price.
But Ms. Bhati, our law permits a single person to adopt a child.
My lords, permit me to come to that now.
Yes.
Your lordships will see this, my lords. The Learned SG did not place it. Lordship may note that this is, my lords, from page 39 to 49 on both the prepositions. The first is, my lords, that the legitimate straight interest, and that I showed to your lordships, and that there are some papers, my lords, on there is lack of data to establish equivalence with biological heterogeneous upbringing of children. Lordship may see it. I just brought it to your lordship's notice because it was the Learned SG left it to me, my lords.
Right.
Now, please come back to my note, my lords. Your lordships will see.
Which is your note now?
My lords, your lordships had my note, welfare of child. I was.
1 second, yes.
I'm sorry, this.
To go back.
Written submissions on behalf of.
Yeah.
So I've said only NCPCR, but it's also the ministry and CARA. My lords will have para 8, my lords, at internal page 5, at page 5 of my submissions. This I have placed. The second preposition is.
I don't know which page, sorry.
When Ms. Bhati will.
I'm sorry, my lords. Yes, my lords.
Yeah. This is para 5 at page 4.
No, but which note is?
This is the
Note,
Bhati's
you're
note.
talking of note.
There's only one note. Written
Yes, my lords. Yes, my lords.
gender fluidity, right?
Yes, my lords. That I just mentioned, and then I came to part B, which is at page 5. I hope my lords Justice Kaul have my lords the
Yes, I have it. That welfare of children is paramount and
very
sacrosanct.
grateful, my lords.
Click on Aishwarya Bhati and you'll get.
Eight. My lords, I only touched the prepositions in part A because it has been extensively dealt with, and I am at my lords para 10 now, my lords.
Para 10.
State as parents patriae of children, my lords. And this is critical, my lords. I will show to your lordships the Juvenile Justice Act, because the entire architecture, when it comes to the legislations with regard to welfare of child, my lords, it's the child alone who has rights. And my lords, it's in sync with the UN Child Right Convention. It is in sync with the constitutional philosophy and ethos. And please see how the Juvenile Justice Act deals with. May I request your lordships to take my compilation A. I put the acts there so I can show.
Why don't we go through your written note? That might be much better so that, we can get
Then your
the
lordship will
structure in our mind.
Wherever necessary, we will go there.
So, my lords, I'm not touching this aspect of parents patria any more than mentioning it that it's the
Absolutely.
settled.
Very well settled, so you don't have to read out the case law.
From your lordship's judgment.